Hi, good afternoon. It's about 1 minute after the hour, so I'm going to go ahead and get started for those of you on the line. My name is Meghan Hubbard. I practice in the Private Wealth Services Group at McGuire Woods here out of Richmond, Virginia. And this is the first installment in a three-part series that the Private Wealth Services Group is doing, a virtual seminar series. So I'm glad you could join us today for our first session. I will leave some time for question and answer at the end. And to the extent we don't get to any of those, if you do submit questions, we can certainly follow up with you directly. But with that, I'd say sit back, relax, and maybe enjoy some lunch during this hour while I discuss settlor intent. So today, we're going to discuss the role of settlor's intent in trust life of the trust by exploring judicial and non-judicial modification of trusts and mechanisms to enforce a settlor's intent, right? In an age where the law has seemingly, become increasingly friendly to changes and deviation from that intent. So what are mechanisms we can use to enforce it? And how does the existing landscape enforce that intent? So as we know, irrevocable trusts have really just become a very important tool in our planning. There's important benefits for asset management, protection of those assets, planning for estate, gift, GST tax. But that irrevocable, seemingly unchanging nature of those trusts can lead to questions of interpretation over time. Or often by the beneficiaries to modify or terminate those trusts over time. And when it comes to those questions, often the interests of the settlor, the trustee, and the beneficiaries don't align. And just sort of to set the table here, traditionally, the intent of the settlor was the cornerstone of trust law, and courts would regularly look to that intent to guide trust construction and administration, right? So one of my favorite quotes that you see cited often throughout case opinions is this idea that the settlor's intent is the pole star of trust interpretation, right? And that guiding principle. But I think in practice today, with these modern developments in trust law, they've called into question to a certain degree the role of settlor intent and instead give the trustees and beneficiaries wide latitude, right? And the tools that they have to potentially administer or modify trusts in ways that may conflict with that settlor intent. And I'd say really for over a decade, following the adoption of the Uniform Trust Code by many states, the enactment, and more widespread use of decanting, right, over that same period, we've seen this increased flexibility just woven into administration of these irrevocable trusts, right, through tools like non-judicial settlement agreements and decantings, as I mentioned, right? So I think while we saw that flexibility initially with the ability to use UTT provisions in the past 5 years, I'd say, we've now seen, or I've observed a lot more cases discussing and shifting the focus back to a settlor's intent as the guide to taking certain actions with respect to irrevocable trusts, right? So an increase of cases discussing what constitutes a material trust purpose, for example, or at least just an increase of cases that have actually, made their way through the courts and have given us some good guidance. So today I'll focus on really understanding the role of settlor's intent in today's trust administration, right? So by examining the Uniform Trust Code and case law as well. And then second, just those mechanisms a settlor or really even a trustee, right, who's seeking to enforce and effectuate that settlor's intent, can employ in those relevant documents to enforce that intent. So judicial oversight of trusts. As I mentioned, settlor intent has historically been recognized as this, paramount in trust law. This is the quote I mentioned earlier, right? That you see, I've seen in cases time and again, you see it cited in briefs, right? It's this whole star of trust interpretation. And a key component of whether a particular action or modification is appropriate is that settlor intent. And many states, as I mentioned, right, have adopted the Uniform Trust Code, including the states where I practice, primarily Maryland and Virginia. And the UTC, regularly uses the settlor's intent. Excuse me, let's see if I can advance this slide to 6. There we go. Regularly uses the settlor's intent as that measure of whether a modification or action with respect to a trust is appropriate, right? And this is often expressed as a material purpose of the trust. So under the UTC, there are certain actions that can be taken by a trustee or the beneficiaries or collectively, right, with the approval of the court, provided such action does not violate a material purpose of the trust. And I'm going to go through those today. They're listed here. And I'm just going to sort of expand on those and tie those to how a settlor's intent comes into play when seeking to pursue any of these actions with court approval, right? So first up, a court may modify a trust upon the consent of all beneficiaries if that court concludes that modification is not inconsistent with the material purpose of the trust, right? So we have that material purpose standard again. Next, a court may modify a trust if, because of circumstances not anticipated by that settlor, modification will further the purposes of the trust, right? So that's not the material purpose standard, but it's furthering the purpose, right? So, and we have the circumstances not anticipated by the settlor, right? So really a consideration of what the settlor was thinking when they put those documents together and created that trust. Correcting mistakes, reformations. A court may reform a trust, even if unambiguous, to conform to the settlor's intentions, if it is proven by clear and convincing evidence that both the settlor's intent and the terms of the trust were affected by a mistake of law or fact, right? So that gives us some flexibility, but again, goes back to that settlor's intent. Tax objectives. This is just to achieve the settlor's tax objectives. The court may modify the terms of that trust in a manner that's not contrary to the settlor's probable intention. Removal of a trustee again. And this is in a trustee removal, the settlor's intent factors in as well, right? So a court can remove a trustee if there's been a substantial change of circumstances, or removal is requested by all qualified beneficiaries, and the court finds that removal best serves the interests of all those beneficiaries, and again, is not inconsistent with a material purpose of the trust. Also, a suitable successor trustee must be available, right? Lastly, I'll mention, I skipped this one. In addition, under the UTC, if a settlor and all beneficiaries agree to a modification or termination of a trust, the court will or shall, that's the language of the UTC, the Uniform Act. States, of course, have adopted different provisions, but the court shall approve that modification where you have the settlor and the beneficiaries consenting, even if the modification or termination is inconsistent with the material purpose of the trust, right? So here we have a settlor participating, so that material purpose standard does not come into play in the same way. We have that settlor who is able to protect his or her own interests. So material purpose, right? This is the term that we keep referring back to today. What constitutes a material purpose? And the comments to the UTC state that a material purpose must be of some significance, right? Case law, the restatement of trust, similarly says that material purposes are not readily to be inferred, and that a finding of a material purpose requires some showing of a particular concern or objective on the part of the settlor. For example, a concern regarding the individual's skills or judgment or level of maturity, right? A reason for retaining assets in trust and having withdrawals at certain ages, the identity of a trustee, those sorts of factors. Both the UTC and case law confirm that really a case-by-case analysis of that specific trust instrument is required to ascertain any specific material purpose. And we're going to go through some of the cases on this issue, and you'll see that really it is so fact-driven. It's hard to universally say that, one specific item, the appointment of a corporate trustee, for example, is always going to be deemed a material purpose. But we'll discuss some of the cases in a minute. I mentioned this at the beginning of the presentation. Over the past 5 years, I'd say we really have gotten more and more guidance from the courts on what may constitute a material purpose, right? That may prevent modification or cut in favor of modification, right? It can go either way. And I'm going to walk us through some of these opinions. And as practitioners, I feel like my first 7 or 8 years of practice, there was just very little out there that provided guidance. And now all of a sudden we have sort of a plethora of cases that are giving us some guidance on material purposes. Excuse me. And part of it is, and you'll see later today, just sort of based on the age of some of these initial filings versus when we get to an opinion, is some of it just took a while to make its way through the court, right, and end up on appeal and have a published opinion on some of these issues. So what are some of these just categories of items that courts have determined to be material purposes? One, the identity of a trustee can be a material purpose that has come up time and again, right? And I mentioned that it is a fact-specific analysis, right? Because in some instances, it will be a material purpose, in others, it will not, right? It really depends on the language at play there. In Ray Graham estate, this is a Tennessee court opinion from this year, actually. And that case held that naming a corporate co-trustee was not a material trust purpose, right? And allowed a modification to depart from the initially named corporate co-trustee. But contrast that to the Fenske case, which is out of Nebraska from several years ago. And that court found that the settlor had appointed a corporate trustee and that the family's attempt to remove that corporate trustee and appoint an individual related to the family beneficiaries was inconsistent with the material purpose of the trust, right? So in that case, the court noted that in cases where it is important to the settlor that a particular person or entity with particular qualities serve as trustee, then replacement with a person or entity that actually lacks those qualities would violate a material trust purpose. And I really, in my practice, see this come up time and again with beneficiaries potentially seeking to reduce trustees' fees, right? There's been a corporate trustee in place. Often the family member beneficiaries over time think that the asset shouldn't be held in trust at all, and they would have preferred to have received them outright. And then sort of an outshoot of that is sometimes that ultimately ends up in them challenging or becoming disgruntled by just a standard corporate trustee fee and pleading that as grounds to potentially remove a corporate trustee requirement, right? And we've seen courts saying, no, that's a material purpose. The settlor did that on purpose, and so we must honor that, and it's not a permissible modification. We have the Milton Scarsden Living Trust opinion. This is from 2021. This is out of Minnesota. And in that case, the court found that a modification of a trust to allow for sale of certain real property owned by that trust violated a material purpose of the trust. So the court found that one of the material purposes here in the trust instrument at issue was to hold real property in trust and to provide some stable income for the beneficiaries, right? So in that case, because of the language, the specific language of that trust instrument, the court found that granting that power was inappropriate. That's often a standard power that is provided to a trustee, the power to sell real estate. And here it was not granted, and the petition seeking to grant it, given the other terms of that instrument, made it violate a material purpose. Courts have also found that the trust structure itself, can be a material purpose, right? That prevents parties generally from terminating the trust early. And we have a handful of cases on that. I think non-judicial settlement agreements sometimes verge into that area of impermissible terminations, but we have all these opinions that say, the trust structure itself can be a material purpose. And there's two recent cases that I'll go through that sort of, you can see the facts and why the court ended up where they did in finding that this trust structure itself was a material purpose. The first case is the Horgan v. Cosden case. This is a case out of Florida. In that case, Settlor created a trust for the lifetime benefit of her son. And at his death, those assets were to be divided and distributed to, I believe it's 3 higher education institutions, right? So those charities were those remainder men. The Settlor named her son and a close friend as co-trustees of her trust. And ultimately, the son was displeased that his mom had set up this trust rather than giving him the assets outright. Notably, mom did not provide for invasion of principal, so it was only net income that was going to son. But son decided to approach those remainder beneficiaries and the co-trustee initially to terminate the trust early. So this was appealing to those charities as well. And the son and the remainder beneficiaries reached an agreement to terminate the trust and distribute those assets according to the actuarial value of their respective interests, right? And the co-trustee, the friend of the Settlor, disagreed and wouldn't sign off on this settlement agreement for early termination, and argued that it was contrary to the Settlor's intent to provide for his son, her son, throughout his life. And ultimately, the son was not happy with that response from the co-trustee and filed suit seeking court approval of that beneficiary's agreement to terminate and directing termination from the court. And the court ultimately sided with that co-trustee and said no to the requested termination. No, it violates a material purpose, right? So the plain language of the document showed that the Settlor wanted to provide for her son financially via incremental distributions until he died, and then give that remainder to charity, right? So the lack of a right to invade principal and just the trust structure itself were material purposes, right? So that dispositive scheme rendered termination of the trust inappropriate, even where all those beneficiaries agreed to that termination. The next case that focuses on the same dynamic, right? A beneficiary seeking to terminate a trust early. This is a case from this past year, from 2022, out of Pennsylvania. It's in regards to the Trust B under agreement of Richard Wells. I'll call this the Wells case. And here, the trust settlor, Richard Wells, was a resident of Oil City, Pennsylvania. He was a 1924 graduate of the Virginia Military Institute, VMI. And in 1952, he became president of and appointed to the board of directors of First Seneca Bank and Trust Company. And this is important, like a sort of extraneous fact, but it becomes important in the court's decision. Wells created the Richard Wells Revocable Trust, and he named First Seneca Bank and Trust Company as his trustee. And during his lifetime, this was a revocable trust. He amended that trust agreement several times over the years, and each amendment actually included additional provisions for that charitable beneficiary. And in his final amendment, he provided that instead of an outright gift to his charity, BMI, there'd be a perpetual charitable trust. And the beneficiary would receive the income at least annually. It'd be credited in favor of Wells' class. So years pass, the charity decides, well, we could manage this. We'd rather avoid the costs of administration, and didn't believe that they were justified at that point. So they decide to pursue early termination of this trust. They argue that the trust assets were around $2 million, and the income generated annually was about $67,000 per year. And the fees were $18,000 in the ballpark, right? So they just, based on those numbers, said that termination was appropriate. And they ultimately filed a petition seeking termination of the trust, court approval of that termination. The trustee, in an effort to uphold the settlor's intent, opposed that termination suit. And also the Attorney General of Pennsylvania got involved as well and took the same position. Ultimately, the Superior Court of Pennsylvania found that Wells very clearly intended to create a perpetual charitable trust, right? Not an outright gift. And the court stated that since the language and circumstances surrounding the establishment of the trust leave no doubt as to the settlor's intent, there is nothing further to analyze, right? Full stop. And in support of its ruling, the court found that Wells had, first, he'd been president of this bank and trust company, change an outright gift to the charity to a perpetual trust in favor of the charity. And so, if he had wanted to make a gift outright, he could have, right? He did it in trust. And so that intent should be upheld. And in the fact that he had, served on the board, worked at this bank and trust company, he was very well aware of the fees a corporate trustee charges, right? And the court also deemed them reasonable. So that the reasonableness of those fees was not at issue at all. It had more to do with, is there an alternative? And the court didn't care whether there was an alternative, right? Because the important analysis was only what the settlor intended and was the trust structure and this corporate trustee in place, were these material trust purposes, right? So in this landscape where trusts are increasingly viewed as subject to modification, this case, I think, it's a 2022 opinion, really is a good reminder that settlor's intent prevails and the trustee is the party to defend that intent, right? And there's a quote from the case that we've seen before. This is, the intent of the settlor is paramount, right? And if that intent is not contrary to the law, it must prevail. So just another recent case that's emphasizing that principle, right? And I do feel like there was a little departure from that in terms of the flexibility built into some other provisions of the Uniform Trust Code. But these cases are giving us some important guidance again. Again, as I mentioned, you can really see from these cases that the terms of the specific trust at issue, right, and the facts and circumstances of each case are so determinative, right, and can lead to different outcomes here. So it's important to consider, exactly the scenario that you're dealing with. For all these, we have the court as the gatekeeper, right? There's not necessarily a rubber stamp on the trust modification or request to terminate, right? So, and importantly, where there's court approval of that modification or termination or lack thereof, right, we have that important safeguard of a settlor's intent and carrying out that intent. Right. So even if we have those trustees, and this is illustrated by some of the cases I just went through, right, the Florida case where the charities and the son agreed, right, even if we have those trustees, beneficiaries, otherwise approving of the action, that court must agree that the change meets those standards that are generally tied to the settlor's intent as expressed in the trust instrument. So, and I've alluded to this today, all of us are very familiar with non-judicial settlement agreements, right? The question becomes, what happens when the court is not involved? And do we have those same safeguards present with court review? And what are the parameters for modification or trustee acts, really, right, when the parties are not seeking court approval? And, while the UTC and other state laws have codified this principle of settlor intent as paramount, I do think that the UTC and state statutes have really opened the door for actions by trustees and beneficiaries outside of court and less oversight of modification or other steps regarding trust administration, which can have some adverse consequences. And I'll mention briefly before I move on, another action without court involvement is termination of an economic trust, right? A small trust. States have thresholds under which a trust can be terminated, the assets distributed, notice is required, and the trustee is required to distribute those trust assets consistent with the purposes of the trust, right? So there we don't have the settlor's intent in play, presumably, right, because the settlor wanted the assets to grow and be retained in trust, but we still have the purpose of the trust standard. So non-judicial settlement agreements, right? So this is really, I'd say, one of the most prominent tools for out-of-court action, related to trust administration matters. The Uniform Trust Code provides that interested parties may enter into a binding non-judicial settlement agreement with respect to any matter involving a trust, right? So court approval is not necessary here. And interested parties are those whose consent would be required in order to achieve a binding settlement or that settlement to be approved by the court, right? So that's often qualified beneficiaries, but it can extend to others as well, just depending on the particular matter or issue that is being addressed by that NJSA. Virtual representation provisions are applicable under that UTC, right? So that makes it possible to bind minor and unborn beneficiaries to the settlement agreement without court proceedings. So it's a very useful tool that makes NJSAs even more useful. In terms of validity, a non-judicial settlement agreement is valid only to the extent it does not violate a material purpose and includes terms that could be approved by the court, right? So we have that material purpose standard. Again, it's tying it back to the settlor's intent and again to really the court standards, right? So if you're trying to take any of the actions outlined that will require court approval and do it by NJSA, you have to have those same standards in mind. Of course, state law may differ regarding technical requirements, and there's a wide range of situations where NJSAs would be appropriate. A couple, interpretation and construction of a trust instrument, NJSA is a great tool. Approving a trustee's accounting, a common and effective tool. Granting the trustee a necessary or desirable power, right? But you can go too far, as we learned from the case where granting the power to sell real estate was violated in a material trust purpose, right? So it will, again, depend on the facts and circumstances as to whether that modification by NJSA is appropriate. Another action, transferring a trust principal place of administration. Right, and some states have an exclusive list of actions that can be accomplished by NJSA. I believe North Carolina is one. Other states have sort of this broader language at the beginning of this slide, right, where parties can enter into NJSAs with respect to any matter involving a trust. And then you're just looking at applying that material purpose standard, really, an interested party standard. So it just varies state to state. And with an NJSA, any interested person can petition the court to approve a non-judicial settlement agreement, really just to confirm that the representation of parties was adequate, right? So if you had virtual representation in play, virtual representation is only effective if there's no conflict of interest between the parties being represented and the individual signing off on that agreement. So you'd get confirmation that that's appropriate, and also just confirmation that the agreement contains terms the court could have properly approved, right? So it's coming back to that material purpose standard. And as I noted above, that key test of material purpose is still so important in whether a non-judicial settlement agreement is valid, right? Although a court isn't necessarily involved in making that determination. I do think, and I mentioned this a little bit earlier, that, in some cases, this can open the door to a potential abuse, right? So allowing interested parties, notably generally not the settlor participating, to modify a trust without court intervention, right? It can be taken too far. I also think just short of abuse, right? An NJSA may lead to results that are inconsistent with the settlor's intent if such intent was not effectively conveyed as a material purpose in that trust instrument, right? So it's something that the settlor wouldn't have intended, but the language of the document does not convey the importance. So there are repercussions there. I will mention one case, and I have it here, McGregor v. McGregor. This is the Nebraska case from 2021. And it really just illustrates taking a non-judicial settlement agreement too far. And it also discusses this material purpose standard as well, which I keep coming back to. I love all this guidance. We now have one. What constitutes a material purpose? This case is really a cautionary tale. And I'll get into the details because I think it's important to sort of just thinking about this case and the right way to approach NJSAs. So here, Clifford and Evelyn McGregor, married couple, creates separate revocable trusts, funds them with different assets during Clifford's lifetime. And in 2009, Clifford dies, survived by Evelyn, and Evelyn becomes sole trustee of Clifford's now irrevocable trust. And so at Clifford's death, the trust instrument provided for creation of a family trust for Evelyn's lifetime benefit. And at Evelyn's death, those assets were to be divided into two separate, new trusts for the benefit of their two children, Alan and Deborah. And to the extent possible, the separate assets, the trusts were to be funded with equal shares of the family trust assets. I guess there's some real estate, so the equality was a question potentially. Those separate trusts provided that during Alan and Deborah's lives, they were each the primary beneficiary. And at death, they each had a limited power of appointment over the trust assets. And Clifford's trust instrument also stated that the trusts were the separate trusts for the benefit of the kids were to be non-support, discretionary spendthrift trusts with creditor protection. So as I mentioned, Clifford died in 2009. Evelyn begins administering the trust. In 2011, Evelyn, Alan, and Deborah enter into a non-judicial settlement agreement that provides for outright distribution of those family trust assets to Alan and Deborah at Evelyn's death, right? So they were to be retained in trust, but they scratched that, and under the settlement agreement, they provide for outright distribution. Also, the settlement agreement provided that Alan would also receive an additional tract of land that was not originally provided for in the family trust. So deviating from some of those equality principles as well. So that's 2011. In 2017, several years later, I don't know what happened, change of heart, but Evelyn notifies Alan that she's revoking her consent to the non-judicial settlement agreement. And in response, Alan doesn't like this. He files a lawsuit requesting that the trial court enforce the agreement, right? So we just went over this idea that parties to an NJSA can seek court approval of that NJSA to confirm it's valid and enforceable. So Evelyn opposes this, of course, and she requests that the trial court find that, 1, the agreement's not binding, 2, the agreement violated a material purpose of the trust, and 3, that the agreement did not include all potential beneficiaries. After a bench trial, the trial court agreed with Evelyn. Alan didn't stop there. He appealed. And on appeal to the Supreme Court of Nebraska, the Supreme Court agreed as well, right? And the Supreme Court discusses Clifford's intent in great detail. It found that Clifford's overriding intent and design of the family trust was to hold the children's interest in trust and restrain the transfer of such interests. So also, just under Nebraska law, a spendthrift provision is presumptively a material purpose, but that presumption can be rebutted. So it wasn't here. The court found that this material purpose, right, this idea that the material purpose is retaining those assets in trust and restraining transfer of such interests, was evidenced by that spendthrift provision. And also the provisions for the assets to remain in trust, right? Just the very scheme of a trust in the first place. And the limited power of appointment granted to the children over their respective trust assets. Alan unsuccessfully argued that Clifford and Evelyn intended for their trusts to be joint and reciprocal, right? Mirrors of each other, essentially. And therefore that Evelyn's consent to that transfer spoke to Clifford's actual intent, or I guess lack thereof, to place strict limitations on the transfer of assets. Of course, the Supreme Court did not agree with Alan, so it had rejected this argument and found that the trust contained a detailed provision stating that Clifford's trust was to operate independently of Evelyn's trust. So this case has some important takeaways and is interesting, I think, for several reasons, right? First, the timeline at issue really could be incredibly problematic for a trustee and really even beneficiaries for that matter, right? So let's back up. 2011, the non-judicial settlement agreement is signed. 2017, that's when Evelyn has a change of heart and revokes her consent. 2018, Alan files suit, right, asking the court to approve that NJSA. And then 2019 is when the trial court issues its opinion. It's not until 2021 that we have the Nebraska Supreme Court affirming, not affirming the NJSA, finding that the NJSA is invalid, affirming that trial court's opinion that it is an invalid agreement, right? So that is a 10-year period. And, while in this case, Evelyn didn't die during that intervening time, right? So the trust assets, the NJSA provided that those assets would go outright at her death. So that hadn't happened. But you can see how that timeline really could present huge challenges to administration of trusts and create a lot of mischief, right? If the NJSA at issue did something different, right? Like changing the trustee provisions or clarifying the identity of certain beneficiaries, right? Who are then later found to not be beneficiaries, or providing that certain assets be used to fund certain shares, right? And then that funding actually happened, right? So having to unwind all that could prove very difficult. And you can really just see the issues that time delay in seeking approval and ultimately getting disapproval of a non-judicial settlement agreement can create. So I think, the lesson here is that for an NJSA, the material purpose standard still matters, right? And so if you are going to pursue an NJSA, you should seek court approval, right? Contemporaneously before an opportunity or a party has an opportunity to change their mind. So at least you know initially that the NJSA is invalid. And also, along those lines, I think a prudent approach is to potentially make the effectiveness of that NJSA contingent on court approval at the outset. That's something we do often. A lot of corporate trustees are looking for that. And it does provide those safeguards, right? That you have that confirmation that you aren't violating a material purpose. You have all interested parties on board. And so you can proceed and administer that trust pursuant to the terms of the NJSA, right, modifying the instrument with some certainty and without concern. So moving along to other methods of non-judicially modifying trusts. Decanting, I will touch on this briefly. Decanting is a process, by which the trustee of one trust transfers assets of a trust to a new trust, which is either, already in existence or formed by that trustee. And under the UTC, there are various methods of modifying a trust, either formally, informally, judicially, or non-judicially. But for the most part, in these cases, the settlor's intent is important, right? It's an important consideration. Decanting, unlike those UTC provisions, is a further step towards potentially deviating from a settlor's intent. And why do I say that? I think that, decanting can be effective and an efficient way to modify a trust. But compared to methods under the UTC, decanting is more of a departure from our traditional notion of the importance of a settlor's intent, right? Because court approval is generally not required. In some cases it is, but more importantly is because the decanting statutes don't really mention the settlor's intent, right? There's some limited exceptions, but it's not as tied to that settlor's intent in the way that the Uniform Trust Code is. And there are at least 30 states, I think more now, that have statutes, under which a trustee, pursuant to a power to distribute trust assets outright, can appoint those trust assets in favor of another trust, so decant. And, the cases reviewing trustee decanting emphasize the importance of a trustee complying with the strict terms of that decanting statute. So decanting, I'll say, follows more of a rules-based approach rather than a standard-based approach. There's no reference in the decanting procedures to whether that decanting violates the material purpose of the trust or would be consistent with that settlor's intent. So, thus, while that decanting can provide trustees flexibility, the lack of a standard really could mean that a trust is modified in a way that the settlor never intended, or that the settlor would object to. Along those lines, there are some safeguards for the settlor in place. Some states do provide that a settlor is entitled to notice of a decanting. Some states also confer standing on the settlor to petition a court to challenge that decanting, right? So there are some safeguards for settlor in some states related to a decanting. So now that we've really sort of gone through the role of settlor intent and some mechanisms to change trusts, judicially, non-judicially, I'm now going to cover mechanisms to enforce settlor intent in those relevant documents, right? So how do we enforce that settlor intent where there's a concern over whether settlor intent will be followed, right? Working with your client, if you're a trustee, trying to uphold that settlor intent, right? What can we do initially in those planning documents to enforce that intent, right? And I think that, while we have, and we've discussed today, these favorable cases, upholding a settlor's intent in material trust purposes, the time and expense of going to court can be undesirable, right? That McGregor case that we just talked about, that took over 10 years to make its way through the court system, right? So to ultimately hold, well, I guess it wasn't in court that long, 2018 to 2021, but sort of even a 3 to 5 year period, right? That's a long time to ultimately get to the court's decision that the proposed modification violated the settlor's intent. It's a timeline that with expense and certainty, and those are all reasons that persuade me that a settlor should take additional steps potentially to safeguard his or her intent. Or on the other hand, to expressly provide for more flexibility, right? If there are not certain, ironclad provisions that are important to that settlor, allowing flexibility, right? And I think both of those approaches have that intended result of avoiding unnecessary litigation and uncertainty, right? So both a good idea. So first, I think the first sort of important point is just drafting, right, as an option to include in your document references to the settlor's intent and material purposes of the trust, right? So draft in a way that emphasizes the importance of certain provisions, right? I do think there's some downsides to this approach. It is difficult to anticipate many situations, right? And so if you're trying to anticipate many situations, it can really lead to potentially, lengthy or confusing documents. So I think that's the downside of that approach. The other downside really is that by emphasizing certain provisions, are you de-emphasizing other provisions, right? That those other provisions may ultimately prove to be important later during the life of the trust administration, right? And if you've somehow, by emphasizing certain provisions and not others, are you sort of like setting the table for a finding that those de-emphasized provisions can't be material purposes? I don't know the answer to that, but something that occurs to me. Letters of wishes can be an alternative here. And this type of document is expressly not binding on the trustee, but it's informative in setting out the settlor's intent and goals, right? So letters of wishes are expressly allowed by many states' laws. And a trust instrument can incorporate that kind of letter, even if it's written after that trust instrument is signed, right? So I guess the benefit there is it also allows that settlor to update the letter of wishes over time without need to really consult an attorney over technical drafting tips requirements, right? It's an informal letter of wishes, again, not binding, but informative. And I do think, in those cases where the settlor chooses to use a letter of wishes, a trust protector, or similar role might be helpful to ensure that the settlor's intent is carried out there. Trust protectors and trust advisors sort of on their own, regardless of the letter of wishes. Those are also often used as mechanisms to ensure that those trust terms are followed, right? And also that appropriate avenues exist for modification, right? So you can build in flexibility in certain ways, but not always. And a trust protector, this is just a specifically appointed fiduciary or quasi-fiduciary. And I say that, state law really determines whether a trust protector has fiduciary duties, and that varies from state to state. But it's an individual with the power to take certain actions with respect to the trust. And often it's a power to amend a trust in certain circumstances, right? For example, to amend the trust to adapt to tax law, to amend the trust to alter a beneficiary's interests without adverse repercussions for the settlor retaining some of those powers. A power to remove or oversee trustees, that's a common one. The power to veto trustee actions. Those are all sort of actions that you can, or duties or powers you can confer on that trust protector to uphold that settlor's intent. And I'll say that the use of a trust protector has been recognized in the Uniform Trust Code, and it's increasingly recognized by states, and I see them popping up more and more. There's several cases now that sort of give us some guidance on how trust protectors operate vis-a-vis trustees, right? So a common and potentially good approach. Another approach is limitations on applicable rules, right? So this is adding specific limitations on the rules that we just talked about that can be used to modify a trust or take certain action, right? In terms of decantings, those UTC provisions, just adding specific language that's limiting those the availability of those statutes and rules. And the last and potentially very powerful tool for a settlor to protect intent that I'll mention today, this is a no contest clause, right? So, and I don't, these aren't, in my experience, often considered in the context of ongoing trust administration as much, right? They generally come into play in a will contest situation, for example, or trust contest situation, right? Black's Law Dictionary actually defines, no contest clauses, also known as interorum provisions, are designed to threaten one into action or inaction, especially a testamentary provision that threatens to dispossess any beneficiary who challenges the terms of the will, right? So usually it's at the outset of an estate or revocable trust administration, but really no contest clauses are increasingly used in trust agreements, and I think they're an effective and underused tool to uphold that settlor's intent. The important sort of caveat there is if you are going to use a no contest clause to effectuate and uphold your intent as the settlor, you must be in a jurisdiction where those no contest clauses are recognized as enforceable, right? So those are jurisdictions where there's been a decision as a matter of public policy that a settlor should be able to do what he or she wants with his or her property at death, and over the administration of the trust, provided it's not contrary to public policy. Just to set the table here, right? No contest clauses generally will not be triggered by a beneficiary seeking to review a fiduciary's conduct, but will be triggered if the beneficiary contests the terms of the instrument or attempts to take some of the actions we discussed earlier, right? So modification or early termination. And I think whether that's through court or even potentially through an NJSA, right? If the provision is drafted in the right way or otherwise, I think it could get into invalidity there as well. And then we have a recent case out of Wyoming that I think is illustrative of how effective a no contest clause can be. And I'll cover this case. This is it's the Gowdy v. Cook case out of Wyoming from I think 3 years ago. And in this case, Marian Jackson retained an attorney, prepared estate planning documents, and he represented her for a long period of time, 1996 until her death in 2015. He drafted he drafted a revocable trust agreement and various amendments to that revocable trust agreement. Marian was the trustee and primary beneficiary of her trust during her lifetime, very common. And at her death, those trust assets were retained in further trust for the primary benefit of her longtime partner, Gerald Gowdy, for Gerald's life. Marian did name her attorney, Dennis, as the successor trustee to serve after her death, and Dennis's brother and law partner was appointed as trust protector, and he had this ability to remove the trustee. The trust, importantly, contained change of trustee provisions that allowed resignation of the trustee and removal of the trustee by the trust protector, but required that any successor trustee be a corporate fiduciary with assets or insurance coverage of at least $100 million. So it had a corporate trustee requirement. The trust agreement also included a no contest clause, providing that certain challenges to the provisions of the trust would result in forfeiture of the challenger's interest in the trust. So following Marian's death, Dennis began serving as trustee, Craig, his brother, as trust protector. Gerald had also prepared certain documents with Dennis over the years. Several months after Marian's death, Gerald becomes unhappy with Dennis. I think he just wants his assets outright, which is often the case. And he complains that the trust established by Marian for his benefit was being mismanaged by Dennis and asks Dennis to resign as trustee. And Dennis refuses It says that the complaints of mismanagement were unfounded. But ultimately, a year later, Gerald decides to file a complaint in the District Court of Wyoming. He alleges malpractice, breach of fiduciary duties, breach of the duty of good faith, fair dealing, negligence relating to Dennis's drafting of Marion's trust, and also Gerald's various estate planning documents, and also alleging breach of duty in Cook's, in Dennis's administration of that trust as well. Gerald sought various forms of relief, right, damages, but one of the items of relief requested was that the court modify the terms of the trust to repair issues due to Dennis's drafting errors. Gerald's proposed modifications would remove the requirement that corporate trustee serve and have assets or insurance coverage over $100 million, and so in response, Dennis's trustee, upholding this settlor's intent, right, counterclaimed and sought a declaratory judgment that under that no contest provision, Gerald had forfeited his rights as a trust beneficiary by requesting the removal of the corporate trustee requirement. And the Supreme Court of Wyoming ultimately agreed and found that Gerald's attempt to remove certain corporate trustee qualifications was an attempt to nullify a provision of the trust agreement, thereby triggering that no contest clause. The Supreme Court rejected Gerald's argument that no contest clause provision should only apply to challenges to distributions, and said, no, it's the clause itself speaks to contesting any provision of the trust, right? And the Supreme Court said Marion's objective intent, from the plain language of the trust agreement, which, when read as a whole, unambiguously stated that a beneficiary would forfeit his interest if he attempted to avoid, nullify, or set aside any provision of the trust agreement, right? So Gerald's disinherited. And, this may be an extreme result, but in a jurisdiction that enforces a no contest clause, a no contest clause can really be a powerful tool to deter beneficiaries from seeking to modify the terms of the trust. I'll say, real quickly that I think one way to make it less harsh, right, if you don't want to push a full forfeiture, right, would be to allow an individual to withdraw their action once notified of the clause, to non-suit, or to provide notice in advance of the provision. You could also, if you're a beneficiary, could use a 2-count pleading method, for example, asking the court to determine whether a proposed modification as a second count, right? In count 1, whether a proposed modification in count 2 would violate a no contest clause, right? So there's some options there to avoid the harshness of such provision. But again, it will depend on what jurisdiction you're in. And while they seem harsh, I have seen no contest clauses effectively used, time and again to prevent trust modifications or termination that are inconsistent with the settlor's intent, right? And also just to avoid disputes among heirs over these trust construction issues. So it's an effective tool. So with that, I think we're actually about at the hour. I guess I have a minute for questions if there are any. And if we don't get to them, I can certainly circle back. I'd also like to say, we have these 2 upcoming webinars that I'd like to remind you of as part of our series. The next one is on October 5th, and that's Traps for the Wary, Best Practices for Running a Family Foundation. Another one, the third one is on October 12th, and this is Modern Problems Require Modern Solutions, Administration of Complex Estates. And those are both, again, at noon, the lunch hour, and we hope you will join. I thank you for your time and attention today.